Okay, so please bear with me. I'm learning as I go, and this is the very first time I'm using the screenshot and an explanation of what led to my erroneous arrest. I should explain a little bit of history, which is in July, I requested that my attorney withdraw from my case, my court-appointed attorney, because I did not feel that I was getting adequate representation. So she appropriately filed an emergency hearing. However, that emergency hearing was not held until a month later, August 19th. On August 19th, I did enter my appearance pro se and or sui juris, which is more appropriate. But the judge at that time did make a judgment for me to appear on August 25th. Prior to this, I was granted permissions from the court to appear to the court by phone. So she made a judgment again for me to appear August 25th, which then the state attorney, Rachel Coleman, was to write up the order for that judgment. So this is her response. She does state here, and this is in accordance with state statute. She says here, you have three options in this order. You can agree as to form, which means that you agree that the order reflects that the judge stated what the judge stated yesterday, but you do not agree with the ruling. Number two, you can suggest minor revisions, which if the judge attorneys agree with, we can make. Or three, you can propose your own order that is reflective of what the judge ordered yesterday. If you choose to propose your own order, we will have a presentment hearing, which we will present to the judge our proposed orders of what the judge ruled, and she will choose which order is most reflective of her ruling, or she can write her own order. So for anybody who is involved in the system, it's extremely important to understand the entirety of the process. A lot of people don't understand how little things can slight the court, or how attorneys sometimes deviantly sneaks things into the order. Well, this process is put into place to catch those things so that it is a truthful record to what has occurred in the court. And so my response, which you will see right here, is I stated, please revise. Number 4 needed to be omitted. Number 9 needed to be amended. And the state attorney responds and states that she needs to get the order over to the court for the judge's signature. At this point, I would like to write on your signature line, approved as to form, with the exception that I do not agree with the finding in paragraph 4. Do I have permission to put the above in your signature line? Okay, so I should state on August 19th, Rachel Coleman had testified on record that she had been meeting with the state police in order to get me. So in her overzealous nature to achieve that, it was very important to her to file this in a timely manner in order to present it to the judge to force my appearance. So I did respond in a timely manner, in fact, an extremely timely manner, to all responses of the correspondent. So my response here, you can clearly see, is no. Please have the judge review it as previously suggested. She made the comment, but it was not a part of an order. I think that it is being taken out of context to include it in the order. I am not evading, and when I have the opportunity to provide my defense, I think that will be clear. So again, she's already explained the process and when there is a disagreement of what occurs, and clearly I have stated that I want to exact that rate of due process to make sure that the record is accurate. If you see here, this is the order in which the attorney presented to the judge. You can see it does not have yet the signature of the judge yet, and you can see that she put in exactly what she stated she wanted to, despite that I said no. And this, therefore, was denying me the opportunity of due process to argue that this was not an accurate representation. You can see here that the judge signed it. It was presented and signed on August 25th, the day that I was to appear. And here you can clearly see that it was not file stamped until the following day, the day after I was to appear. An order is not effective or enforceable until it is filed. This upholds your appellate rights. In order to appeal, the order has to be filed. August 26th, I had a hearing, which I attended again by phone, and at that time at 10 o'clock in the morning, the judge could not confirm whether this order has been signed nor confirm whether it had been filed. The state attorney did state that it had been signed, but again, neither one of them could confirm whether it was filed. If you see here, it in fact was not filed until 2:40. My bench warrant was filed at 2:36. So after I've already made the argument that this order is not valid because it was erroneously presented to the judge with a fraudulent response from me on my signature line, depriving me of the due process to make sure that there's an accurate record. And secondly, it was not filed in a timely manner. So knowing this, they still entered it and filed it and then issued a bench warrant for my appearance for failure to appear to responding to this order. The bench warrant, again, was filed at 2:36 and right before this was filed. So they had plenty of opportunity to know what they were doing was against my constitutional rights, and in addition, I should state, I did not receive a copy of this order that was filed stamped until August 31st, which is also the day that they issued the Amber Alert erroneously. So I also was denied any notice that they issued a bench warrant. And again, I was representing myself or sui juris, which people might be familiar with, but I have a legal opportunity to know that they are issuing the bench warrant so that I have an opportunity to remedy that. So again, they denied me of such, and as a result, I was arrested and held in jail for 4 days. So that's what I have. So I hope that that brings some clarity on that issue, and I will continue to work backwards in some of the other events that have taken place. So thank you so much for your attention, and keep watching.